Okay, I'm watching a video of someone operating a piece of heavy machinery and it looks like they're about to drive it off a platform. Okay, so let's see this. Okay. Boom. Okay, so they fell off the platform and it flipped over. I hope everyone was okay. All right. Hi, I'm Blake Zaccagnino. I work mostly on personal injury claims in New York State. And what I like to do is I like to make comments about different videos that I see online that remind me of legal concepts. This particular video brought a couple different things to mind. It brought into mind workers' compensation in New York State and also third-party claims that arise out of possible workers' compensation incidents. So generally, in New York State now, I am not a workers' compensation attorney. I work on personal injury claims. So I am not well versed in all of the different exceptions, but generally, if an employee is injured while on the job doing a work activity and in the scope of their employment, generally their only remedy against their employer is for workers' compensation benefits and not a lawsuit against their employer. Now, like I said, there are many exceptions. Every case is different. So it's always important to consult with a workers' compensation attorney that is very knowledgeable of the nuanced details. Where I experience a lot in my work is its interplay with personal injury claims. So generally, if somebody is injured at work, what I am looking out for is who was at fault. Was it somebody other than their employer? If the person or entity that was at fault was not a person's employer, the injured worker may have a third-party claim, which basically means a claim for a separate lawsuit against someone that was not their employer. A couple of things that come to mind in that when there's an interplay between a workers' compensation case and a personal injury case is generally you'll have the person in New York State will have two separate attorneys. One attorney handling the workers' compensation part of it and another attorney handling the personal injury claim, because both cases involve very nuanced and detailed tasks that generally you want someone who specializes in each of those activities and tasks to be handling. And what comes out of a lot of these cases is if a workers' compensation claim is filed and workers' comp is paying for a person's lost wages, medical expenses, or other expenses, generally, if there's a third-party claim, workers' compensation will have a lien on that person's recovery from the at-fault party, meaning if the case settles, then the injured worker will have to pay out of their settlement what workers' compensation paid. So basically, they'll have to pay them back out of their settlement. Now, there's a lot of different avenues where different formulas that happen where workers' compensation will take a look at the whole package and will generally work with attorneys in coming to an agreement regarding a reduction in some circumstances. But the workers' compensation lien is something that has to be handled prior to settling any personal injury claim. And one of the most important things that comes up in these cases is when there's a personal injury claim and also a workers' compensation claim, there has to be formal consent from the workers' compensation carrier to settle the personal injury claim. If the carrier has not given their formal consent under the law to settle the personal injury claim, there could be many consequences that include the injured person not being entitled to benefits anymore, along with many more possible consequences. And I wanted to go over some case law on the topic as well. And a good explanation came from a case, Babcock versus Lamb. That's 247 AD 2D 903. And it says, with limited exceptions not relevant here, workers' compensation is the sole and exclusive remedy available to an employee injured during the course of his employment as against his employer. And it says, moreover, whereas here an employee applies for and accepts workers' compensation benefits, he is deemed to have elected his remedy and therefore forfeits his right to proceed by way of an action for common law tort. The workers' compensation defense precludes plaintiff from bringing this negligence action against a member of the partnership that was his employer. So, in short, if you had an on-the-job injury and it happened in New York State, it is extremely advisable to get a workers' compensation attorney that can assist you on that part of the claim, and also a personal injury attorney that can assist you on that part of the claim. And it will be crucial for both of those attorneys to work together to make sure that the case is being handled properly, because what happens on one case could affect what happens on another case, and both issues on the comp side and injury side are extremely nuanced and extremely complicated issues that need to be fleshed out. So I hope this video was helpful, gave you some helpful information. If there's any particular tasks that you want me to, tasks or topics that you want me to get into, let me know, leave it in the comments. Thank you.